Today, we are unpacking a moment so heavy, so laden with historical gravity, and so fundamentally unprecedented that it has sent a shockwave through the very pillars of the American legal system. This isn't just a headline or a fleeting social media trend. This is a seismic shift in the relationship between presidential power and judicial authority. We are witnessing a confrontation that has effectively shattered every expectation of how a former leader conducts themselves when standing before a court of law. If you value the integrity of our institutions and want to understand the raw truth behind the most tense 6-minute standoff ever witnessed in a federal courthouse, you need to hear every single word of this report. This is the moment where protocol collapsed and the foundation of the rule of law was tested in real time. And before we dive into the heart of this extraordinary event, do me a favor. Hit that subscribe button right now. If you want deep dive reporting that refuses to skip the details and delivers the analysis you won't find in a 3-minute soundbite, join this community. I read every single comment you leave, and I want to know your perspective. Have we entered a new era of constitutional crisis? Smash that like button, and let's get into the details. The scene was set in a packed federal courtroom, a place usually governed by strict silence and rigid decorum. At exactly 2:47 p.m. Eastern on January 26th, the atmosphere didn't just turn cold, it became explosive. During a critical pretrial hearing regarding the handling of classified documents, Judge Aileen Cannon issued a judicial rebuke so direct that legal scholars are already calling it a categorical break from modern American history. But the rebuke wasn't the headline, it was the response. When the bailiff announced the standard, "All rise," a command that has signaled the entry of a judge for centuries, every person in that room, the 47 members of the press, the 8 federal prosecutors, the 12 members of the legal defense team, stood in unison. Every person except one. Donald Trump remained seated, his attention fixed on his mobile device, reportedly scrolling through social media. This was not a minor protocol dispute or a simple misunderstanding. It was a deliberate 6-minute standoff that forced armed federal marshals to step forward, their hands moving toward their restraints as the tension reached a breaking point. When Judge Cannon requested that the former president stand for the court, the silence that followed was described by veteran reporters as the kind of quiet you feel in your chest. After a second more direct instruction, the response from the descendant table was one for the history books. "I don't recognize the authority of this kangaroo court, and I'm not standing for it." In that moment, the basic respect for the court, which serves as the lubricant for the entire wheels of justice, didn't just grind to a halt, it shattered. To understand why this happened, we have to look at the evidence that triggered this level of judicial intensity. Tensions had been simmering for weeks over discovery disputes and what the prosecution has labeled a pattern of deliberate obstruction. But the flashpoint was the unsealing of FBI memos just hours before this hearing. These documents weren't just paperwork, they were a timeline of events that the court could no longer ignore. The memos revealed that for 18 months after leaving the White House, Trump personally retained materials marked top secret in his private residence, even as the government issued repeated demands for their return. The detail in these memos is what makes the situation so grave. We are talking about surveillance footage and timestamps that allegedly show the former president personally moving boxes of classified materials from a secure storage area to his personal office on 3 separate occasions between March and August of 2022. This moves the needle from a dispute over organization to an allegation of deliberate concealment. These boxes didn't just contain miscellaneous files. Sources familiar with the investigation state they held nuclear weapons specifications, foreign intelligence assessments, and military plans for ongoing missions in hostile regions. Perhaps most staggering is the report of audio recordings where the former president allegedly told staff that certain documents should be kept in his personal safe to prove he was right about everything. When Judge Cannon returned from a 23-minute recess after reviewing these materials in her chambers, observers noted an expression on her face they had never seen before. Federal judges don't typically engage in public rebukes over procedural disagreements. They do so when they perceive a threat to the integrity of the judicial process itself. And yet, when confronted with this authority, the defendant chose a path of open defiance. This sends a signal that we have crossed into genuinely uncharted constitutional territory. Drop a comment right now. Did you see this level of confrontation coming? It is vital that we document this shift as it happens. To grasp just how much of a departure this is, we have to look back at 235 years of American tradition. Even in our most fractured moments, the presidency has eventually bowed to the bench. Think about Richard Nixon during the height of the Watergate scandal. When the Supreme Court ordered him to release the tapes, Nixon complied. He understood that while he held the highest office in the land, that office had constitutional limits when it met judicial authority. He surrendered the evidence, even as his presidency crumbled. Look at Bill Clinton during the Paula Jones case. He fought the litigation all the way to the Supreme Court, but when the ruling went against him, he showed up for his deposition. He may have been frustrated, he may have been angry, but he never challenged the basic protocols of the court itself. Even the most defiant figures in our history kept the conflict outside the courtroom doors. Andrew Jackson famously challenged Chief Justice John Marshall to enforce his own decisions, but Jackson never walked into a federal court and refused to stand for a judge while facing criminal charges. Abraham Lincoln may have suspended habeas corpus, but he never appeared as a defendant only to declare the court illegitimate to its face. What we saw on Tuesday, as Harvard Law professor Lawrence Tribe noted, is a categorical break from everything we know about the American constitutional tradition. It reveals a fundamental belief that political power can grant a permanent immunity from legal accountability. This isn't just an American phenomenon. The world is watching. When you look at how other global leaders have handled similar legal pressures, the contrast is stark. Former French President Nicolas Sarkozy stood for his judges. Former Israeli Prime Minister Benjamin Netanyahu, despite his fierce rhetoric outside the court, followed every protocol inside it. Even South Korean President Park Geun-hye maintained decorum during her impeachment. In a democracy, the system only works if everyone, including those who once held the levers of power, accepts that the law applies to them. When that acknowledgement is withdrawn, experts on authoritarianism warn that the system itself begins to tremble. The implications of this standoff reach far into the practical world of law enforcement. The federal marshals in that courtroom were placed in a nearly impossible position. Their training is clear. If a defendant refuses a judicial command, you escalate from verbal warnings to physical restraint. But these protocols were designed for ordinary citizens, not for a former president flanked by a Secret Service detail. Reports indicate that real-time coordination was required between agencies that day. No one wanted to be the first agent to put hands on a former president. Yet no one wanted to be responsible for the total collapse of judicial authority. It was a 6-minute vacuum of power that has left the Department of Justice and the Marshal Service grappling with how to handle future appearances. And the ripple effect is already hitting courtrooms across the country. Defense attorneys in major cities like Chicago and Miami are reported to be already citing this precedent, arguing that if a former president can ignore courtroom decorum, their clients should be afforded the same leeway. This creates a two-tier justice system that federal prosecutors warn could undermine every criminal case in the nation. Either the rules apply to everyone, or they eventually apply to no one. There is no middle ground when it comes to the all-rise command. Looking ahead, the legal fallout is likely to be swift and severe. Judge Cannon is expected to rule within a 72-hour window on whether to hold the former president in contempt of court. For any other defendant, this behavior would result in immediate detention. For a former president and current candidate, the decision carries weight that could alter the course of the 2024 election. It changes the dynamic of every pending case, from bail conditions to sentencing considerations. Judges in every jurisdiction now know that they are dealing with a descendant willing to test the physical boundaries of their authority. Even those who have frequently defended the former president's legal positions, like Professor Jonathan Turley, have acknowledged that this crosses a constitutional line. You can challenge a ruling, you can appeal a decision, and you can criticize a judge in the press, but you cannot openly defy the authority of the court while sitting in it. This has moved beyond a legal strategy and into the realm of a fundamental challenge to the civilian control of our legal system. The reaction from the political world has been just as fractured. Senior GOP officials reportedly held emergency calls to decide whether to frame this as justified civil disobedience or an indefensible liability. Meanwhile, the former president's response on social media has only doubled down, labeling the judge nasty and claiming that standing for a court violates First Amendment rights. He has even characterized the federal marshals as a personal enforcement army, further escalating the rhetoric against the very people tasked with maintaining order. My dear viewer, we are at a crossroads. This isn't just about one man or one trial. It is about whether the principle of equal justice under law still has a pulse in the 214th year of our republic. If the presidency is viewed as a lifetime shield against the basic requirements of the justice system, then the very nature of our government has changed. We are watching a constitutional crisis unfold in real time, and the next 72 hours could determine the trajectory of American law for the next century. If this deep dive helped you understand the gravity of what happened in that courtroom, please hit the like button. It genuinely helps this reporting reach more people who need to see past the noise. We are committed to bringing you the facts, the history, and the analysis that matters. Keep a close eye on this story, because the moment of truth for our legal system is here. Thank you for watching, and I will see you in the next update.